Okay, so welcome everyone to this webinar about structured rights information at Europeana. If that's okay with everyone, we'll get started because there's a lot we want to cover today and we don't want to keep you longer than promised. So today it's going to be Masha Skriniar, data ingestion specialist at Europeana, Adina Chikoyu, who just turned off her camera, but she'll be helping us with the Q&A and to moderate the discussion. And then myself, Ariadna Matas, policy advisor, and we all work for Europeana Foundation. As you probably know, this webinar is part of a longer series of webinars about copyright when sharing data with Europeana. The aim of this series of webinars is to raise the understanding on how to deal with copyright when you actually submit data to Europeana. But some of these webinars will not be so much focused on the internal functioning of Europeana, so they're open to anyone who is interested in this topic. So today it's going to be more focused on rights in digital object and using right statements when submitting data to Europeana. So it's very much based on the systems we rely on. But then in October, we're going to have a webinar about clearing rights in collections with Naomi Korn, who is an expert based in the UK. In November, we're going to have a webinar about opening collections app. And then in December, another webinar about the copyright in the Digital Single Market Directive and the new approaches it presents for the public domain and for out-of-commerce works. You can already sign up for the October one, and the two following webinars, we will confirm the speakers and the dates shortly, and the information will be posted in the usual channels. And those who have already signed up for the first webinars, we will also send you an email because we understand you've got an interest in the whole series. And Masha will go through a couple
Ariadna,
of...
before you continue,
yeah?
there were some notes that people cannot hear us. Is that the case for most of you? Yes, okay. I got that there are some that can hear. So yes, thank you very much for your confirmation. Yes, for those that cannot, please check your computer or your audio setup. Sorry for interrupting you,
Thank you.
Ariadna.
No worries.
Go ahead.
Thanks, Adina. Hi, welcome everyone. I'm Masha. Let's go quickly through housekeeping items. So we are recording this webinar and we will share the recording and slides with you after the webinar. As you probably noticed, we muted your audio and videos. So if you have any comments or if you would like to introduce yourself, please use chat. And for all the questions for Ariadna and myself, please use the Q&A box. And you will see that you can post questions for all panelists, and you can also vote for the most interesting questions. And we will then dedicate time throughout the webinar to answer those questions. Maybe we won't have time for all of them because we only have 1 hour. So it's important that you vote for the ones that you find most interesting. Back to you, Ariadna.
Okay, thanks, Masha. And so what are we going to talk about today? We're going to start with the principles that Europeana relies on around copyright and the documents in which they are embedded. Then we're going to talk about standardized rights information, so Creative Commons licenses, Creative Commons tools, and rights statements. Then we're going to give you a couple of tips on how to accurately choose among this selection of rights statements, Creative Commons licenses, and Creative Commons tools when you submit data to Europeana. And then finally, the last part of the webinar will be working with examples. So all these principles that we will have presented, we will put them into practice with a couple of examples from works that are in Europeana collections. And back to you, Masha.
Thanks. So let's start by looking into rights information and how it is presented in digital collections. So when digitizing works and putting them online, some institutions choose very restrictive statements, such as all rights reserved. Some other institutions provide a long textual description, and they usually include contact details of the authority, like Picture Library, that's responsible for managing digital objects. And then other institutions just provide boilerplate copyright claims. They attach them to all their objects in their collections. And it's usually the year when the digitization was made, followed by the name of the institution. So these are all just a few examples you can find if you browse different digital collections. Some organizations use completely different approaches, but these are a few most common ones. And when institutions provide information like the one that you see in front of you, this actually makes users work a lot harder because it doesn't actually say how the users can interact with the objects. So they need to do their own research into copyright. And sometimes these statements are also a bit misleading because they indicate that the objects are in copyright, which is not actually always the case. So to avoid this confusion, in Europeana, we suggest that you use standardized rights information. And this is also something we encourage our data providers to do. So in the example in front of you, you can see the record from the Europeana portal. And this is an image of a painting that's in the collection of the Rijksmuseum. And right underneath the image of the painting, you can see that this image is clearly marked as being out of copyright. You can see the public domain badge. And when users click on that, it takes them to the public domain mark deed. And this is where it's explained that this object is not protected by copyright. And it also informs users that they can copy, modify, distribute, and perform the work, even for commercial purposes, without having to ask for permission. And when you provide standardized rights information, you actually make it really easy for the users to understand how the digital objects can be used. You can also specify whether there are any restrictions on the use or not. These are widely adopted standards that are not just used in Europe, and they use legally accurate language to describe the rights. Standardized rights information can also help institutions to provide more trustworthy information. For example, if institution is using boilerplate copyright claims for all the objects in collection, but not all objects are protected by copyright, this can result in claiming copyright on objects that are in the public domain, so copy fraud. If institutions wish to provide standardized rights information, that means that they need to carry out a rights audit. They need to already know what the copyright statuses of the objects are and so on. And all this results in more accurate copyright information. And finally, while free text information is only human readable, if you use standardized rights information, this means it will also be machine readable. So that means that the rights information can be found by search engines. And in case of Europeana, this means that our users can search and facet on copyright values when they're using Europeana collections. And I think we can go back to you, Ariadna.
Okay, thanks. So thanks for that. This provides a bit more context on why we think standardized rights information is useful when communicating digital cultural heritage. And so let's now dive into the principles that Europeana relies on when it comes to copyright, which are embedded in 3 important documents: the Europeana Data Exchange Agreement, which is part of the Europeana Licensing Framework, the Europeana Publishing Guide, and the Public Domain Charter. Starting with the Europeana Data Exchange Agreement, this is basically the contract that exists between Europeana Foundation and the institution sharing data with Europeana. And when it comes to copyright, it basically says 2 important things: that the metadata that the institution provides will be labeled as CC0, which is the Universal Public Domain Dedication by Creative Commons, allowing anyone, anywhere to use this metadata freely with no restrictions. And then secondly, about digital objects, as the one you saw in the page that Masha just shared, we asked our data partners, the institutions providing the data, to choose a rights statement from the list of rights statements that we work with that correctly indicates the copyright status of that object. in this regard, we put a lot of emphasis on the fact that we would like those sharing data with Europeana to particularly be careful about respecting the public domain. So whatever is in the public domain in the physical world needs to really be labeled as with a right statement or Creative Commons tool that indicates that it is in the public domain. A second important document, the Europeana Public Domain Charter. This one is not really a contract. This one is a policy document that explains our position towards the public domain. And so we say we understand the public domain as being the material from which society derives knowledge, and we consider the public domain as having social and economic, an important social and economic impact on society, on the well-being of society. And that's why then we follow with the principle that is clearly explained in this public domain charter that says that whatever is in the public domain in the physical world should not be brought back into being copyright protected in the digital world. So there should not be additional layers of rights placed on a public domain work just because it's been digitized.
And the last very important document is the Europeana Publishing Guide. And I'm sure that our data providers are very familiar with it. So Ariadna presented the Europeana Data Exchange Agreement in the beginning, and that's a legal document. But in contrast, the publishing guide provides instruction on how to provide metadata to Europeana. And it also provides some important information on copyright. It specifies that each digital object submitted to Europeana needs to be labeled with a right statement. And that right statement needs to be from the list provided by Europeana. And I will tell you a bit later on which are the tools that we are working with. And we also ask our data providers that the provided right statement is as accurate as possible. What does that mean? It should accurately reflect the copyright status of the object, and it should also accurately reflect permissions on reuse that were granted by the rights holder. And as I said, let's now look into the tools that are being used by Europeana. But before we go into that, I will just quickly check if there are any questions so far.
Or Adina, maybe you've kept an eye on that?
So I can
yes,
so
far there are no questions.
Okay, thanks.
Yeah.
Then let's move on to the standardized rights information and how you can provide them using which tools. At Europeana, we have 14 available right statements, and we use the term right statements for all these different groups of Creative Commons licenses, Creative Commons public domain tools, and right statements that are provided by rightstatements.org. So our providers can choose between 6 basic CC licenses, 2 public domain tools, and a subset of 6 right statements provided by rightstatements.org. Rightstatements.org provide 12 right statements in total, but Europeana is only using it's only using 6. And those are the ones that are suitable for our and European legal environment. We can now look at the Creative Commons licenses in more detail. They were created to empower creators to allow reuse of their works. So by using Creative Commons licenses, creators grant free access to the work, and they can also specify the type of reuse they allow. They can be applied by or with authorization of the copyright owner, which can be problematic for cultural institutions because they're not often the owners of copyright. And it's important to remember that physical ownership doesn't automatically mean that you also own the copyright. So if you acquired the object in your collection, that doesn't automatically mean you also own the copyright. Creative Commons licenses should only be applied to works in copyright, And we can see that some institutions out there are applying CC licenses to scanned copies of public domain materials. And they have good intent. They're trying to promote and encourage reuse. But public domain works, by definition, don't have the rights holders because they are no longer or were never protected by copyright. So nobody can apply a Creative Commons license to a public domain work. They are non-exclusive and irrevocable. And what do I mean by that? When I say they are non-exclusive, this means that owners can enter into additional different licensing arrangements for the same material. So for the institution that's digitizing a painting, for example, that means that they probably produced images in different resolutions, and all these different resolutions can have a different CC license attached. And by irrevocable, I mean that they are perpetual. So once the license is applied to the work and the work has been made available to the public, the rights owner cannot simply change the license. They can, authors can choose to stop distributing the work online, but if users already downloaded that object and are using it under that license, then it's their right to continue to using it. So based on all this, why do we think at Europeana that it's a good idea for institutions to use Creative Commons licenses? They are certainly the easiest way to communicate to the public what uses can be made of the digital object. They lower the barriers to access and reuse, and we believe that this creates more opportunities to signal the value of collection. We, of course, understand that rights management is demanding and it requires lots of resources. That's why it's often seen as a burden for cultural heritage institutions. But actually, when institutions get in contact with rights holder, this can, of course, contribute to developing new relationships with creators and donors. And let's quickly look at what uses can be allowed by applying CC licenses. So as I mentioned, we have 6 basic licenses, and each license contains one or more of basic licensing elements. And copyright owners can then decide in advance what level of reuse they would like to allow. And the 4 basic licensing elements are attribution, which, as you can see in this diagram in front of you, is the core condition that's attached to all Creative Commons licenses. It means that you have to credit the author of the work or other nominated parties. The other element is commercial use, which specifies whether others can use the work commercially. Then we have modify and adapt, which specifies if other people can make changes to the original work and whether they can build new works on it. And change license, which specifies whether you can change the license type for your adaptation of the original work. So the difference between the 6 basic licenses is how many of these elements apply. We have the CC BY license at the top, which is the most permissive one. The only requirement is attribution, and the most restrictive license is at the bottom, and you can see that it doesn't allow modifications or commercial use. Now, as I mentioned, the Creative Commons licenses can only be used on works that are in copyright. And for works that are no longer subject to copyright protection and can be used without restrictions, we have 2 public domain tools that are offered by Creative Commons. The first one is CC0, or public domain dedication. It waives all copyright and related rights in the work immediately, and it places the work in the public domain. The person that created the work is the one that can also dedicate that work to the public domain. And the second one, which is well-known public domain mark, is used for labeling works that are no longer protected or were never protected by copyright. In case we have any collections managers among us today, we do advise that you update your collections databases on a regular basis, because it's very likely that each year some of the objects entered the public domain and are no longer protected by copyright. And we also have this problem at Europeana. Some of our data sets haven't been updated in a very long time, and the copyright has expired in the meantime. So those objects are now incorrectly labeled in the Europeana portal. So we do encourage all data providers to give us updates for those records where copyright has expired. Now let's look at the rightstatements.org and how they are different from Creative Commons licenses. Rightstatements.org provides 12 right statements that were created for unique environment of aggregators and cultural heritage institutions. They should not be applied to works by general public. They were designed to provide solution for those institutions who want to share their digital objects online, but are unable to apply CC licenses. Now, this can be either because they don't have permissions from the rights holders, or there are some other restrictions that limit the reuse of digital objects. It's important to know that right statements are not legal tools. Only a copyright holder can apply CC license, but rightstatements.org can be applied by cultural heritage institutions that are not copyright owners. There are a few things you should consider before applying them. They are divided into 3 main groups. So we have statements for works in copyright, not in copyright, and where copyright status was not established. So it is important that you have clarity on the copyright status before you apply them to objects. When you're using right statements, that doesn't mean that you don't have to seek permission from the copyright owners to make those works available online. So if you're dealing with objects in copyright, if you're not the copyright owner, and if you cannot make objects available under fair use or exceptions such as orphan work, then you will need to have a permission from the rights owner to make these objects available online. And just a last quick tip, this is something we notice in Europeana quite a lot. So we ask providers to map the URI of the statements in the metadata, and often instead of URI, providers give the web address of the statement. So please don't do that. It's worth going to the relevant page and just look for the URI. Sorry, it's usually somewhere below the text that describes that right statement. At Europeana, we only use a subset of 6 right statements, and I will quickly present which right statements they are. So we are using in copyright, which can be used for items that are in copyright, but the rights holders haven't allowed any additional reuses. Then we have in copyright educational use permitted. It's for in copyright works where the copyright holder specified that he or she allows the use in educational purposes. Then we have the EU orphan work. Orphan works are works where copyright holder could not be identified or located. This, of course, is problematic for institutions because it means they cannot get permissions to show those objects online. And to deal with this issue, the EU Parliament adopted the Orphan Works Directive. So if the digital object was recognized as an orphan work and is part of the EU Orphan Work database, then you can apply this statement. And then we have 2 statements for objects that are not in copyright. No copyright, non-commercial use only. This indicates that the digital object is not protected by copyright, but the owning institution is contractually required to restrict certain commercial uses of the object. We know this is happening in projects like Google Books, for example. Then we have no copyright other legal restrictions. This covers works that are in the public domain, but there are legal restrictions imposed by laws other than copyright that restrict the reuse. And the last one, copyright not evaluated. This is seen by us as a right statement of the last resort because it indicates you haven't done anything to try and find out the copyright status of the work. And here you can also have a look at the 6 remaining statements that are not used by Europeana. So basically, we offer this combination of Creative Commons licenses and tools and rightstatements.org because they cover the full spectrum of possibilities for our data providers. And Ariadna will tell you more about how to choose the correct right statements later on, but let's go to the questions, if we have any. No.
So far, no questions, Masha. There was a note from Ignacio in the chat. Maybe you can have a look at that.
Okay, so Ignacio is stating that CC by ND and CC by NCND were marked as licenses that allow a change of license in derivative works, as CC by and CC by NC, but in fact, they do not allow derivative works by default. It is possible that, let me check what we say in that graph. So they do not, CC by ND doesn't allow derivatives, which is correctly marked, and CC by NC ND also doesn't allow commercial use and adaptation. So not sure if that's clear, Ariadna, or whether we should make any other.
So with a non-derivative restriction, if you make a derivative work out of the original work, then you would not be allowed to share it. That's what this license establishes, if my understanding is correct.
Yeah.
Okay, shall we move on to the next part? Or I don't know if Ignacio is responding.
Take and change license. So the last one, CC by NCND. Yes, that's right. You're correct. Yeah, I understand what you mean now. So by default, because it doesn't allow any derivatives, there's no point in changing the license. Yeah, that's a very good point. We'll change that. Okay, Ariadna, yeah, we can move on to the next part. Sorry, I'm just going to move the slide.
Okay, great. And feel free to keep posting your questions while we speak. So after Masha's presented the suite of statements that we rely on, we'd like to give you a couple of tips on how to accurately choose them. Because there's often some content on Europeana collections that is inaccurately labeled, and this might come from a lack of understanding of the different layers of considerations that an institution needs to go through to make a correct determination. So we try to simplify things a little bit, and here's a formula for you to consider when you choose a right statement. First of all, you should note whether the work is in copyright or out of copyright. So first, check the copyright status of the work, and here we're talking about the physical object, not the digitized version. You should know if the work is in copyright, then who the rights owner is and who holds the rights. The third thing you might want to consider is to not claim any additional rights obtained through digitization in line with our public domain charter. The first step would be to look into whether there are other restrictions, not necessarily copyright restrictions, but other type of restrictions that might limit the use of the work by others. So you need to communicate it to the users. And then the last step, once you've cleared all this out, and let's imagine the work is in copyright, then would be to decide how much you want to open up. So if you choose a more open tool or license or a more restrictive one. With all these considerations, you should really get to finally choosing a correct right statement. So we're gonna go one by one now. Clarity in the copyright status is very important because not every statement can be applied to any work. If you determine that the work is in copyright, your choice of statement will be reduced to a narrower choice of statements. If you determine that it's in the public domain, then you're going to have another set of possibilities. And the statement really needs to be very truthful in reflecting whether the work is in or out of copyright. The second important step would be, if the work is in copyright, then you need to obtain the rights from the rights owner, because first of all, as Masha was saying, you will need to permission to put the content online if you are sharing it with Europeana, and then unless you go for a risk managed approach. And then second of all, when you have the choice of licenses or statements, you need to know to what extent the rights holder wants other people to reuse the content, because it's not your decision, it's the decision of the one that has the rights. Remember that having the object in your collections does not mean that you have the rights on that object. And so these steps are a bit, they go a bit in the direction of how to clear rights. And this is something that Naomi Korn will cover in the second webinar. But just to give you a couple of ideas, to know who holds the rights and to get the rights for your institution to be able to then follow all the steps that I was saying. Maybe your institution did obtain the rights when the work was acquired. If not, maybe you will need to locate the rights holder and ask the rights holder directly for permission. There's also the possibility that you can rely on collecting societies if they do represent the works in question, or if you are in a country in which extended collective license is applicable. And then other than that, there might be exceptions to copyright in your country, like the orphan works exception, in which you can rely to be able to make this content online without needing the permission from the rights holder. I'm picturing this as if it was extremely simple, and we are very aware that this is really, really complicated. And so this is just a very simplified approach, but we know there are many nuances that make all of these steps extremely challenging for institutions. In any case, we just wanted to highlight that whenever you're thinking of sharing the work online, you're going to need to have clarity on where the rights are if the work is in copyright, and to obtain them. Then another important step that is in line with our public domain charter would be to not claim any additional copyright on digitization. So whichever statement you choose should be based on the copyright status and the conditions of the work, and then there are exceptionally some restrictions on the deriving from the digitization, but not based on copyright. As I was saying, our public domain charter says that the digitization of public domain content does not create new rights over it, so works that are in the public domain in analog form should continue to be in the public domain once they have been digitized. I wanted to stop a little bit and look at this topic because we've got an impression generally that given that the fact that we often see works that are in the public domain labeled as if they were in copyright, there seems to be a misunderstanding, and sometimes there's like this urban legend that anything that is digitized can have new rights, which is very far from being correct. So I just wanted to stop and tell you the very few situations in which this right might eventually exist, so that you understand that in most cases, there's not even legal grounds to claim these additional digitization rights. And even if there were any of these legal grounds, we really encourage you not to, so that you don't undermine the public domain, which is such an important area for the well-being of society. So the only two possibilities through which these so-called digitization rights could actually exist is, first of all, if you are in a country that recognizes neighboring rights for non-original photography. So the idea was that photographs that are not artistic have some sort of protection, but these rights are not harmonized across Europe. They only exist in Austria, Denmark, Finland, Germany, Iceland, Italy, Norway, Spain, Sweden, and Switzerland. And given that they're not harmonized, each country sets different conditions and different durations. So for instance, in Italy, they exist for 20 years, I think, from the moment the work is digitized, or from the moment the photograph is taken. And in Spain, they exist for 25 years from the moment the photograph is taken. there's less rights recognized. For instance, there's no moral rights. So there's not this full copyright protection. It's, these are the so-called neighboring rights. And they differ from one country to the other. The second, but I wanted to say that in this case, you should, in any case, check your legislation and the case law in your country, because it might be the case that a very faithful reproduction of an artwork does not even meet the threshold, the requirements to actually rely on this type of protection. So even if you're in a country in which this protection for non-original photography exists, you really need to check, because it's very possible that it does not really apply in the context of digitizing cultural heritage. The other option that could offer legal grounds to claim this protection is if the digitization of the original work is a new work of art. So if this image of the sculpture is a photograph that is artistic in itself, and then it gets full copyright protection. But as you can imagine, this is extremely difficult. So an image that tries to be as faithful as possible to the original will, in very rare cases, be a new original work. So you should note that these digitization rights in most cases do not exist, and claiming rights that don't exist is claiming something that is not enforceable in the end. Even when they exist, we encourage you not to claim them and to respect the public domain. It's important to note also, although this will be discussed in the last webinar of the series, the one on the Copyright Directive, a bit more in depth, that the European legislator has also given its opinion on this matter, and this principle that I was sharing that we have in the Public Domain Charter has now become law and will be enforceable in all European member states by the 21st of June of the coming year. So in the Copyright in the Digital Single Market Directive, through Article 14, the European legislator says that when the term of protection of a work of visual art has expired, any material resulting from an act of reproduction of that work will not be able to be subject to copyright or to related rights unless it is an original work. So what this article basically says is that from June 2021, it will no longer be possible to claim this first possibility to claim protection on works of visual arts that are in the public domain. So going back to our list, our formula, step number 4 would be on restrictions besides copyright law that the institution digitizing the work and making it available might need to indicate to the user. So really think about whether there are any of these that you need to highlight to inform the user. And there's 2 statements that can help you make this information available to the user in a simplified way. First of all, if the type of restrictions that might limit the possibilities to reuse the work are legal, but not based on copyright law, so for instance, privacy concerns or cultural heritage laws that might establish some restrictions into the use of the work, then you can use the no copyright, other non-legal restrictions. This is of course for works that are out of copyright. So copyright is not the barrier, but there might be other barriers that apply. And the second one, the second type of restrictions that one could see are contractual. So as Masha explained before, for instance, with the Google Book projects, if I understand well, the Google funded this digitization, but established that a 10-year, for a term of 10 years, no commercial use could be authorized of these works. So this is not a copyright limitation, this is a contractual limitation, which you can indicate by using the statement, no copyright, non-commercial use only. So now you've considered several elements. Let's imagine the work is in copyright, but you have the rights. The last question you should ask yourself is whether your institution is willing to open this up to the public for reuse. And so then you're going to have a selection of possibilities from more open to less open to choose from. So to a large extent, whether you choose CC BY or CC 0 will depend on the approach that your institution is willing to take. And of course, Europeana encourages you to open up as much as possible. So just to wrap up this part, our recommendation would be that first, you decide whether the item is in copyright or in the public domain or other. In this case, you will have a narrower choice of statements, and then from there you keep narrowing down the possibilities by checking whether you actually have permission or not, or there are any type of contractual or legal restrictions or not, etc. So, any questions up until now?
No questions, Ariadna, all quiet. Yeah, you can go on, probably the examples. Oh, there's a question. Yes. Could you once again, from Chiara, could you once again explain the difference between CC0 and public domain and when they each apply?
Yeah, Masha, do you want to take this one first?
Yeah, sure. So the public domain mark means that object is in the public domain, whether it was protected by copyright and that protection expired, or it was never protected by copyright. CC0 means that the object is now in the public domain, but that's only because the rights holder waived all his rights. So he said, I'm the rights holder, but I'm placing this object in the public domain. Sometimes institutions on Europeana also use CC0 in cases where, like Ariadna was saying, the neighboring rights on non-original photographs apply. Let's say we have a digital object from Italy. Italians know they can claim copyright protection on that digital object, but they say, no, we're going to place it in the public domain because we don't want to claim that additional protection. Or Rijksmuseum released their material under CC0. In case there is any copyright, we waive all the rights and we place this in the public domain.
Yeah, I don't have anything to add from my side.
I hope that was clear, Chiara. Let us know if, yes.
Thanks for the
Great.
question.
Yeah, so we can move on to the other part.
Okay. Are there other? I saw like some.
Yes, there was Alessandro thanking you for the reply, the response to Chiara's question. No other questions so far.
Okay, great. So yeah, what we're going to do now is test everything that we have just told you through examples that can be found on Europeana collections. I just wanted to start with a little disclaimer. For the purpose of creating these examples, we're going to share works that are really on Europeana collections, but we don't have all the information that would be needed to go through this formula. So there's some information that is made up, and also we've simplified a little bit the calculation of when a work enters the public domain, because there are still differences that apply across member states in the EU. So it would be a bit too complex if we had to take this into consideration. So this is more to test the process and the thinking rather than to focus on the little details. I hope that's, we still hope that's going to be useful.
So let's look at the first example, which is a collage that was provided to us by a Swedish data partner. The description is in Swedish, but it says that the artist is Jonas Liveroth, and it actually mentioned that this work was created for the exhibition in the Providing Museum, and that exhibition opened earlier on in 2020.
Okay, so Masha, what is the copyright status of the object?
This is a work by a living author and it's still in copyright.
Okay, and does the institution that hold the work actually also have the rights?
No, they don't.
Do we know who holds these rights?
Yes, so the artist is mentioned in the description and his name is Jonas Liveroth.
Okay, and did the artist, the copyright holder, grant permission to the institution to allow any reuse of the digital object?
No, but he's fine with publishing this object in Europeana. So he didn't give permission to use any of the Creative Commons licenses, and he also doesn't allow educational reuse. So based on that, institution has two choices. One could be EU orphan work, but we know who the artist is. And we also already told you that the museum did contact the artist. So this is not an option in this case. So the only option that remains is in copyright rights statement, which indicates that the object is in copyright, but that the artist didn't allow any reuse on this digital object.
Okay, great. So second example.
The second example is from Catalonia, and it's a manuscript from 1708.
Okay, and in that case, what is the copyright status of the manuscript?
It's already out of copyright.
Okay, are there, maybe you want to clarify the options then?
Yes, so this is a question we get quite often. So for works that are out of copyright, we of course have the two Creative Commons public domain tools, CC0 and public domain. But then we also have two options from rightstatements.org. And those two options are no copyright non-commercial use only and no copyright other legal restrictions. And as Ariadne explained, those two options can be used when there are other restrictions that apply on the reuse of the digital object.
Okay, so to narrow down our choice, are there any of these legal or contractual restrictions that apply in this case?
Yes, so this work was actually digitized in a public-private partnership. And as specified in the digitization contract, the users are not allowed to copy, modify, distribute, or execute the work for commercial purposes.
Okay.
So the most accurate right statement in this case is no copyright, non-commercial use only. In case data providers are using this statement for the objects that are providing to Europeana, we would also ask them to indicate the first calendar year in which the digital object can be used without restrictions on the commercial use. Of course, if they are allowed to provide such information to us, that really depends on the digitization agreement in this case.
Okay, great. Next example.
So this is a black and white photograph from Latvian Museum of Energy, and it was taken by Edward Kaus, who was a photographer and film operator, and he was documenting power plants in Latvia.
Understood. So then what is the copyright status of this object?
We have the life dates of the photographer, and we know that he passed away in 1977. So that tells us that this photograph is still in copyright.
Okay. And does the institution that holds this photograph in the collections also have the rights?
Yes, so the photographer actually assigned copyright to the museum.
Okay. Would the museum like users to be able to interact with the object without any restrictions, given that it has the rights and so the choice?
Yes, so we were actually in touch with this museum and they were quite keen to allow the reuse of the object. So they were thinking about different possibilities, and we suggested to them that they can use CC BY license, CC BY SA if they wish to be slightly more restrictive, and CC0. And the museum selected the CC BY license, which requires users to attribute the owning institution and also the photographer.
Okay. Next example.
So this is a map of Slovenian land from the beginning of 18th century. It was issued in 1714.
Great. So what is the copyright status of this map?
So this map is out of copyright.
Okay.
So again, as we explained before, we have different options. We have two Creative Commons public domain tools, and then we have two right statements provided by rightstatements.org.
Okay. So again, to narrow down the choices, do we know if there are any legal or contractual restrictions that apply in this case?
No, not in this case. So the most accurate public domain tool in this case is public domain mark.
Okay. I can clarify that in Europeana we have these public domain guidelines, which are some non-binding guidelines, but still we encourage people using the content in Europeana collections to follow them, that clarify that even though something is in the public domain, it's still very important that users are respectful to the author, the providing institution, that they give credit where credit is due, and that they are culturally aware of the context in which this content was made available. We can go to the next example.
Yeah, so this is a book from collection of early printed books from Serbia, and it was published in 1538 in Venice.
Okay, what is the copyright status of the book?
It's out of copyright. So again, we have option of to public domain tools and to rightstatements.org.
And are there contractual or legal restrictions that apply?
Yes, there are in this case, and the provider also indicated in the data what those restrictions are. It's really nice because if you follow that link, you can also see the English translation. And it actually says that there is a law on old and rare library materials in Serbia, which means that the owning institutions need to be informed about commercial uses, and they need to give approval for any commercial use, even if the object is already in the public domain.
Okay, so what is the final statement then?
Yeah, so in this case, the provider selected no copyright other legal restrictions, which is completely right. The only thing we ask when data providers use this right statement, please also communicate the legal restrictions that apply.
Okay, I think that's the last example. Yeah.
Yeah, this is the last example, and then we can go to questions. So this is a book of songs from Croatia that was printed in 1917.
Okay, and what is the copyright status of this book?
This book is actually still in copyright.
Okay, and does the institution that holds the book in the collections also have the rights?
No.
Is the copyright holder known then?
Yes, in this case, we know who the copyright holder is because he's mentioned on the book cover, and his name is Vinko Jarkovic.
Okay, was the institution able to actually contact or locate this copyright owner and get permission to be able to then grant reuse?
No, so they know his name, but they were not able to locate him.
Okay.
So again, we have two options. This could be orphan work, depending on whether the institution did due diligence, or it could be in copyright right statement. And this is actually relating to the question that was asked, is it allowed to show copyrighted material at Europeana? So the short answer is yes, but you need to have a permission from the copyright owner. So the copyright owner needs to say, yes, it's fine with me if you publish digital object on Europeana. And in this case, we know that the museum was not able to locate the copyright owner, so they don't have permission. But in cases like that, institutions can still take risk-managed approach. So they can examine what the risks for the institution are in case they don't have permission from the copyright owner, but they still publish something on Europeana or anywhere else online. And depending on their internal policy, they can decide they're fine with it and they're going to take a risk. So in that case, it is possible to publish in copyright work without having a permission.
But this is something that is, as Masha was saying, is a decision of the institution at Europeana. We don't interfere in this decision. So we rely on your judgment and then publish in copyright works. Yeah.
So in this case, in the case of Croatia, they actually did the diligent search, and this book was recognized as an orphan work on the EU level. And the institution also recorded this object, and it's part of the EU Orphan Works database.
Great. So yeah, I think we're done with the examples, and maybe we can just take some questions now. We've got 5 minutes left.
Yeah, so there was this question from Dirk that Masha just answered about the uncopyrighted material at Europeana. There are two more in the chat, one from Erna regarding the photograph of the plant. She's asking, what about the copyright of the architect? That must also be taken into consideration. The copyright of the architect of the plant, of the photographer who died in 1977. Yes.
Yeah. So yes, definitely. And here's where, before I try to say that we're oversimplifying things. So I'm not sure whether this architectural work would be subject to protection, whether it's original or not. Maybe, I mean, this is for the judge to decide. But if we were to say we want to assume it is, then definitely you might have a work that contains other works inside that work. And that's one of the biggest challenges that cultural heritage institutions face, because then the clearing rights is a never-ending story. But you should, yeah, definitely. I would advise then if there are several works remaining in this, you wouldn't have cleared copyright completely until you have got the rights from, all of the authors of these works, and therefore, if you only have the permission of the photographer, maybe it wouldn't be enough to then go ahead and say it's CC BY.
I would just say that this also depends on your internal copyright workflow. So, you know, in this case, I think it is possible to argue that this power plant, the photograph of the power plant doesn't require to ask the architect for permission as well, but just the photographer. But it really depends on how you define risks within your institution, how thorough you want to be. But if you deal with objects where there are multiple layers, like Ariadna was saying, it's good if you make some kind of decision, how deep are you willing to go?
And for instance, the Orphan Works Directive that Masha was talking about, one of the big flaws for the sector of this directive is that when it talks about this diligent search, you need to do this diligent search not only on the main work, but also on the works contained in the work. So if you've got a scrapbook that gathers pieces of newspapers, of letters, of photographs, then you need to clear right on every single item inside this, which is definitely problematic. And that's one of the parts of the Orphan Works Directive that was most criticized. Hopefully the new rules will be transposed in every member state in a way that does not have this important limitation. So that then when you clear rights, you just clear it on the main work and don't need to be checking everything that is contained in it.
Yes, there was a note from Anna regarding your comment, Masha, about the object is the photograph and not the building, and it was with a question mark. So when, I think now with all the explanation, this clears it up. And also
but this is an artwork made by this photographer. He used creative choices how he's gonna photograph this power plant. So the digital object here is a scan of the original photograph.
Yeah, and I think in photography, it's always very complex to determine whether a photograph is actually a work protected by copyright or not. And that's why member states have been struggling throughout the years, and then some have ended up defining this lower level of protection for photography. And so, yeah, determining whether a photograph is original or not is a very complex question, and I don't think we can solve it here.
There is another question from Carolina. Could you please explain a little bit more the concept of out of copyright?
This basically means that the object is in public domain, but the object is in public domain because the copyright has expired. So we can have objects that were never protected by copyright, and they're also in the public domain. But in all these cases, they once were protected by copyright, but it expired. And there are usually the law in the EU is that the copyright expires 70 years after the death of the author or the last living author. But there are, of course, still some variations in national legislation.
So I hope this answers your question. There is another question from Alessandro. What about multi-layered complex objects, for instance, newspapers? Artworks, photos, even in the font face and the page layout can be associated with multiple copyright holders.
Yeah, I think we more or less talked about it, but yeah, that's definitely a very complex question. In the case of newspapers, I think most European member states treat them as collective works. So in some occasions, they can be treated as a work as a whole, with the exception of a couple of elements that might be contained that don't really pertain to this collective work. But other than that, that's one of the biggest problems in clearing rights, where you have content that has several layers of protection. So even, I think audiovisual works are the most difficult example, where clearing rights probably gives you a lot of headache, because you might have music, costumes, tons of things. Sometimes all the rights are given to the producer. Sometimes that happens automatically, but then these are the kind of things you need to check on your legislation.
Yes, there was some notes also related to the photograph, that yes, there was a mention of freedom of panorama exception on copyright. And then Ignacio said, if in your country there is an exception of freedom of panorama, of the copyright of the architect could be waived.
Yeah, to some extent, although this is again, another right that is not harmonized across the EU. So some countries will have it, and it's definitely very useful, and some others don't. And it's based on the idea that if a work of art is placed in the public space, then as Ignacio was saying, users are allowed to reproduce it. And I can't remember what other rights are accepted from this exception. But yeah, that would definitely be helpful whenever it exists for cultural heritage institutions clearing rights.
And Erna was stating that this is not a panorama photograph. In such a photo, the object takes up only a small part of the photograph.
Okay, but
yeah,
the concept is not so much about
yes.
it, but it's a legal concept about a work of art being placed in the public space.
Yes. Okay, Carolina is thanking you for the answers, and I think we covered most of the points raised in the chat and in the question section.
Okay.
Yeah.
You always, you've got our contact details. If you've got other questions, feel free to email us. Yeah. And Masha, I think you were about to wrap up.
Yeah, so I think this is a wrap. Thank you so much for all your questions. We will check the recording. Hopefully it's good, and we will share that with you, and also the slides. So feel free to reuse the slides. We license them under CC by SA license.
Thank you, everyone.
Thanks for joining.
Goodbye.
And yeah, the other webinars are also going to be interesting, so feel free to register and welcome and join us next time.
Great. Thanks everyone, and see you next time probably.
Yeah. Bye.
Bye.
Bye.